Meeting of the City of Selma Planning Commission, November 12th, 2019, is now in session. Commissioner Curry, could you lead us in the flag salute, please?
Please join me in saluting our flag. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Could we have roll call, please?
Yes, sir. Commissioner Curry,
here.
Commissioner Fedor,
Here.
Commissioner Garcia,
Here.
Commissioner Gonzalez,
Here.
Commissioner Sikan,
Here.
Chairman Niswander,
Here.
and please note Commissioner Singh is absent.
Good evening, members of the commission, staff, ladies and gentlemen. The Planning Commission is now in session. Copies of the agenda for today's meeting are in the entryway on the table by the door. You can help us expedite tonight's hearing by following these rules and procedures. Everyone will be given an opportunity to be heard. When it is your turn to speak, come to the podium and state your name and address clearly for the record. The applicant and those in favor of the application will speak first, then those opposed to the application will be heard. After that, the applicant will be given time for rebuttal, and if necessary, those opposed will be given the opportunity to rebut. We ask that you limit your presentations to 3 minutes or less. This should be more than enough time for a well-organized presentation. The chair reserves the right to limit testimony and will exercise that right in the interest of others who have business before the commission. After all speakers have been heard, the hearing will be closed. At that point, additional comments from the public will not be allowed unless one of the commissioners asks that the hearing be reopened. Finally, the commissioners will discuss the application, make motions, and vote to reach a decision. If you are not satisfied with the commission's decisions, you may be able to appeal the decision to the City Council. Appeals must be filed within a specified period of time after today's hearing, and you can check with staff for the procedures to follow in filing your appeal. Please make sure your pagers and mobile phones are on mute. Thank you. Potential conflicts of interest. Any commissioner who has a potential conflict of interest may now identify the item and recuse themselves from discussing or voting on the matter. Under oral communications, notices to the public. At this time, any member of the public may address the commission regarding any item over which the commission has jurisdiction. No action or discussion will be taken on any items not on the agenda. Issues raised will be referred to the chairperson for review. Members of the public shall limit their remarks to 3 minutes. Under consent calendar, all items listed under consent calendar are considered routine. The complete consent calendar will be enacted by one motion by roll call vote. For purposes of discussion, any commission member may have an item removed from the consent calendar and made part of the regular agenda. The commission can then approve the remainder of the consent calendar. Number 1, consideration and necessary action on the minutes of the October 28th, 2019 meeting. If everyone's in agreement that these are accurate, I will entertain a motion.
I'll make a motion to accept them as submitted.
Okay, I have a
You're good,
motion.
I'll second.
I have a motion and a second. You want to do roll call?
Commissioner Curry,
Yes.
Commissioner Fedor,
Yep.
Commissioner Garcia,
Yes.
Commissioner Gonzalez,
Yes.
Commissioner Sikan,
Yes.
Chairman Niswander.
Yes.
Thank you.
Moving forward, under public hearings, item number 2, consideration and necessary action on alternative resolutions recommending either repeal or amendment of Selma Municipal Code 11-8-10 to provide for discretionary modification or adjustment of density requirements for retail outlets selling packaged alcoholic beverages in neighborhood commercial zone.
Mr. Chairman, members of the commission, you're all familiar with section 11-8-10, subdivision D of the Selma Municipal Code, because you just recently denied a CUP that sought to establish a convenience store at which alcoholic beverages and containers were sold at retail, based on that section, which in essence says that if you're an establishment of less than 15,000 square feet and within either 300 feet of either a school or a park, or within 500 feet of an existing retail outlet selling that same product that is also less than 15,000 square feet, the CUP cannot be issued or approved, and you have no discretion to approve it. As your commercial district fills in the availability of space in which to build that type of a retail outlet necessarily decreases over time, and you ultimately reach a point at which it is impossible to locate a space where you can establish that type of business in conformity with that rule. And that typically, although not always, will lead to a legal challenge of your rule on the ground that it is either arbitrary or not rationally based on any evidence that is designed to serve the purposes for which the ordinance exists. The purpose of this is apparently, and I say apparently because you don't really know what the intent of it is, but the apparent purpose is to cut down on overconcentration of retail outlets selling alcohol, and perhaps to eliminate public consumption of alcohol at city parks or in school parking lots. And the reason those get challenged and the way you can deal with that challenge, that potential for a challenge, is to alter the rule to build into the rule some discretion that the Planning Commission can exercise based on legitimate, non-discriminatory reasons, and come to a decision as to whether or not this particular facility under consideration ought to be granted the CUP, notwithstanding the fact that it is within those limitations. So what we are proposing is twofold, and we have a preference. First of all, we were proposing repeal, because that's one of the options available to you. If you repeal the ordinance, you've received a list of all of the enterprises out in the city of Selma that have liquor licenses. You have reached a level of liquor license concentration in this city where under statute, ABC will always come back to the city and ask the city for a finding of convenience and necessity. And they will not issue the license to that enterprise if the city does not make that finding. That's part of the Business and Professions Code, and that would be in effect in the event that you repealed this. We are offering a amendment to the rule that essentially gives this planning commission, which makes determinations on CUPs, the discretion to evaluate whether or not there is really an adverse effect on property within a 300-foot radius of the proposed retail establishment that is going to sell alcoholic beverages, and or whether allowing that use promotes the public convenience or necessity, much in the same way that ABC would seek a finding from the city relative to an additional liquor license. And we've set out a number of...
One moment, please, Neil. Twice now you've referred to we. Who's we?
Staff.
Staff. Okay, thank you. Go ahead.
We've set out a number of considerations that would be appropriate to take into account, such as the total square footage of the facility, the area that is going to be devoted to alcoholic beverage sales, just how close the facility is to a city park, school, or existing retail outlet. Our purpose is not to encourage public consumption of alcohol or to encourage the oversaturation of the city with alcoholic beverage retailers. Our purpose is simply to alleviate a potential for a challenge to this particular ordinance. Because if you're a convenience store coming in here for a CUP and you're denied based on a prophylactic rule like this, without any consideration of your particular circumstances or what the effect of your business really is on the surrounding area, that almost always leads to a challenge that your ordinance is invalid for one reason or another. Either it's discriminatory. Here you could say it's discriminatory because you're allowing them if they're in excess of 15,000 square feet, and there's no evidence to suggest that public consumption of alcohol and or concentration of alcoholic outlets is enhanced more or less by a store that is less than 15,000 square feet. So we're simply trying to build into the rule some discretion that the Planning Commission can exercise to determine whether or not issuance of the CUP is warranted. At the end of the day, you may go through this exercise and find that it shouldn't be allowed, which is fine. But you will have exercised your discretion, and instead of challenging you based on the existence of an arbitrary rule, they would have to challenge you for abusing your discretion, which is a much, much more difficult challenge to maintain. So we've proposed a specific amendment to the section, which contains broad considerations for the Planning Commission to take into consideration. We've also provided you with a proposed ordinance that would outright repeal this section. And if you did that, you would be relying on ABC to come back to you for finding of convenience or necessity, which is pretty much the same thing. It's an exercise of discretion based on the circumstances of the specific business involved or proposed.
Do we also have the opportunity to leave it as it is?
You do.
Okay, let me ask you this, offhand, since you've been with the city as an attorney for quite a while, has the city ever had to go to court over something along these lines, as you recall?
The city has been challenged on various ordinances, on a variety of grounds. None that are specifically like this, but this is the kind of thing you see in the case law out there. You'll have a rule that essentially says you cannot allow a specific thing because of its location in the vicinity of something else. Typically, it's a requirement that something has to be 300 feet from a school or a church or a park or something like that. Those things usually get challenged by people who have been denied applications to establish whatever business they're trying to establish within that radius, on the grounds that in enacting the ordinance, the city council or whichever body adopted the ordinance did not have a rational basis to conclude that the particular activity involved would have an adverse impact on something else that is within that 300-foot radius. There's scores of cases involving those types of challenges. And as I said, my primary purpose here is to build in some discretion into the application of the rule so that a challenge of that rule is almost certainly destined for failure, because in order to prove that you've abused your discretion, I have to prove that you have exceeded the bounds of reason, which is almost an impossible hurdle for me to jump. Whereas proving something like that sets an arbitrary line, 300 feet, is arbitrary, it's pretty easy to do.
Well, we've already got problems with our parks here in Selma, and it's not a pretty thing to watch, but we've already got problems with I think now they call it Veterans Park. Everybody's running up to the shopping center there and getting a little brown bag and staggering across Rose Avenue, and they're a nuisance in the park, and they do that all day long.
Yeah, and that's one of the factors in the list here. There's A, B, C, and D. One of the factors in that list is the type of park or school that is within the 300-foot radius. And in the CUP that you considered, the park that was within the 300-foot radius is, I believe, a skate park.
There's two parks.
There is a portion of it is a skate park, but
Yeah.
there's also a portion of it that the church across the street uses with their school. They take the little kids across the street at recess time and let them play in that park. And that's a genuine concern of mine. The other thing is the 500-foot rule of a like business. If a business goes in where it's proposed and they're selling the same thing as the business across the street, is that not going to detract from both of them? And we've already got on the west side of the highway 2 outlets for alcohol within 100 feet of each other. And they're right across the street from a grammar school, kindergarten and first grade. So it's not that I don't want to see the city with their tax revenue. It's not that I don't want to see someone come in and build a business and be successful. But we had an incident up here, or a situation similar to this up here on Floral Avenue where the current Walgreens drugstore is. They built a mobile station and whined and cried till they got their way with the council. And within 6 months of getting their alcoholic license, their beverage license, they went broke. The station
Sorry,
got
let me
dug up.
interrupt you on that. That, it did not go broke. My husband was a partner in that. The owner of the land let the land go foreclosure,
Oh.
and the bank kicked us out.
Oh,
That
that's how
business was
Walgreens got there.
thriving.
And these are all legitimate concerns. All
So-
I'm saying is what I'm proposing as an amendment to it tells you to take these things into consideration. The over-concentration of retail alcoholic beverage outlets in the area. You take that into consideration, you may find that, there's just too many of them in this particular area. Or it's too close to this park at which we're experiencing, people walking over to the park and sitting on the bench and drinking there. And we're already experiencing the problem. That's why it's asking you to take those things into consideration. And when you take those things into consideration, what you're doing is you're exercising your discretion based upon the particular circumstances that are confronting you. And you can very well go through all of those considerations and come to the conclusion that no, you shouldn't issue this CUP. And if what was proposed was what you characterized, hopefully that would be the conclusion that you would arrive at. All we're trying to do is take a rule that forbids you from issuing a CUP under any circumstances if they meet these requirements, and asking you to take a look at the actual project that's before you, at the actual surroundings of this project, and determine whether or not you're going to have an adverse impact on that surrounding area, or you're going to exacerbate the already bad conditions in that area. And if you come to that conclusion, you should deny the CUP.
So,
I'm just saying that if you go through that exercise and you deny that CUP, the disgruntled applicant is going to want to challenge you, and he's going to want to challenge you based on this ordinance, if you leave it the way it is.
Right.
If you change it to allow you the discretion to examine all these things and make a reasoned, rational determination as to whether or not this is a good thing or a bad thing for Selma or the surrounding area for this project,
so if we-
that will go a long way towards shielding the city from legal challenges based upon what is arguably an arbitrary rule.
So if we go with this suggestion here on the amendment,
Mhm.
that will give us a little more room to investigate, and we can still determine that, no, we've got too many outlets in this area, or for whatever reason, we can still determine that, no, this should not be granted.
That's what it's there for. And it's only there because we're concerned about somebody being denied a CUP and going to court and saying, I was denied a CUP because these folks have an arbitrary rule on the books and they had no rational evidentiary basis on which to conclude that my project was a problem for the area within 300 feet or affected other retail outlets that are 500 feet or less away from me.
So it seems to me that this will also make it easier for the city of Selma to make exemptions.
This makes it impossible to make exceptions, so you're right. This allows for exceptions. So yes, I mean, I can't argue with that.
Exceptions or exemptions?
Exceptions. I'm sorry, I may have said exemptions.
Yeah, and that's really the crux of it. If you have a rule that doesn't allow for exceptions, no matter, how wonderful this particular store might be, how beneficial this particular store might be for not only the city, but for the surrounding area, you can't approve it. And you'd be looking at it and saying, well, we actually need what this person is offering at this location, but we can't approve it because you're running afoul of our density rule. So yeah, you're right. It does make it easier for the city to allow exceptions to that, but it also retains the city's ability to control it and to individually evaluate each of these projects as they come before it to determine whether or not the CUP ought, in the interest of the public, ought to be granted or should not be granted.
So our ability to deny doesn't change at all.
Doesn't change at all.
Actually gives us more,
A little more leeway.
yeah,
So
and
basically,
more backing too.
we wanna take 300 feet entirely, or can we go like 150 to it, or something,
Well, you have in your packet the proposed amendment,
Yeah,
and one of the proposals was to eliminate it entirely.
no, no, no,
I don't recommend that.
Repeal.
I think it's there, and it's there for a reason. Part of the reason being the number of liquor licenses you've got in the city of Selma. Okay? So what I'm proposing is a simple amendment to the rule that adds an additional paragraph number 3 that basically says this: the Planning Commission or the City Council on an appeal from the Planning Commission's denial of a CUP can adjust, modify, or completely eliminate this requirement, but only if it determines that it will not result in an adverse impact on property within a 300-foot radius of the proposed project, or that conditions can be imposed in your CUP relative to the sale of alcoholic beverages that lessens that impact to insignificance, or you find that it promotes the public convenience and necessity, which is a legal term that has a very definite definition and meaning, because it's the legal term that is used in the Business and Professions Code under which ABC issues its licenses.
And how about the like 500 rule for the other businesses now, I think?
The 500 feet rule is something, that the 300-foot radius thing is something you see all the time in city ordinances. The 500-foot rule here, I've never seen anywhere else ever. And to me, it's kind of problematic, because if you allow, for example, a convenience store that is across the street from a different convenience store that sells beer and wine, and you allow this convenience store, but you don't allow it to sell beer and wine, you're putting that person at a competitive disadvantage to the guy across the street, right? The other thing you're doing is you're treating small stores differently than you're treating big stores. And it doesn't make rational sense, which is why I have problems with the whole section. It doesn't make rational sense because there's nothing that you can point to that says it's more likely that I, as somebody who goes to a convenience store and buys a six-pack of beer, is more likely to go park in the school parking lot that's less than 300 feet away and drink that six-pack than it is if I bought that same six-pack at a Walmart that exceeds 15,000 square feet, right? So in a way, it's discriminatory, and it's picking winners and losers among, similarly situated businesses, which is really not something the city should be involved in. You let the market take care of that.
Well, just as we can have 35 restaurants selling burgers in the town, we don't have a say, so.
Yep.
Each person chooses where they want to go, so.
Any other questions?
What does a developer coming in, is there any guidelines then for him to see, or is it just a crapshoot for them to come in and hopefully they have to go before the planning commission and they get a CUP?
They got to come before the planning commission and convince this planning commission that their business, their sale of alcoholic beverages, if they're within those limits,
Right.
promotes the public convenience and necessity, and you get to
As
go.
it is now. Whereas if we changed it, they have to come before us regardless to
Well,
plead their case, if we amended it.
If you leave it the way it is now,
Right.
and I'm a developer,
Right.
and I have a brain,
I'm going past Selma.
I'm not even going to bother.
I know, that's kind of my question.
I'm not even going to bother, and some of these guys will just not bother and sue you instead.
Yeah. Kira?
I just wanted to add, I think there was a question asking Neil if he had seen this anywhere else. And I will say the city of Fresno has it and the city of Stockton has it, but they provide exceptions. So they do have a 500-foot separation from other establishments for smaller, alcohol, like convenience stores basically. But they do provide certain, exceptions, as we call them, where discretion can be used to approve or not approve these type of establishments.
Which is what we would get if we went with the amendment.
Right.
Which is
Correct.
exactly,
Yeah.
and exactly why I think Stockton and Fresno's ordinances are like that.
Right.
They
Right.
built in that discretion because
It's a
they
fail-safe.
know what's going to happen if they
Right.
leave it like this.
Any other question? Thank you. Does anyone wish to speak in favor of this proposal? Does anyone wish to speak in opposition? Seeing none, I'm going to close the public portion and bring it back to the Planning Commission for discussion and a motion. I kind of like the idea, I don't know how the rest of you feel, but I kind of like the idea of amending it
Yes.
to
Yeah.
still allow us to do our research, or our due diligence. But I guess the one thing that sticks in my craw is as to what instigated this meeting tonight, or our topic, was that applicant even aware that this ordinance existed when he first applied to the city to build there?
That would be a question.
Yeah, I found what we call a PRC letter from 2017, and it was not mentioned. But one thing I can possibly side with Bryant on this is it's possible that they said, we want to build a service station. And although when I see that, I usually assume that probably includes alcohol sales. If they didn't say it in their project description, maybe no one mentioned it because they had never mentioned it. So we would have been looking at, yes, a gas station is allowed, and we would have moved forward from there. But if we had, you know, true due diligence may have
Question that.
may have gotten them there, but because this code is there and it's for the public, anyone can read it. It's online, packaged alcohol sales, you know. But no, it doesn't appear that that was mentioned in the original application in 2017 on either side, that they were selling or that they couldn't sell.
Okay. Well, getting back to it, I kind of like the idea of doing an amendment to the ordinance
Yes.
Yeah.
to cut down on legal fees.
Right.
I don't know how the rest of you feel, but speak up.
This is just a recommendation to the city council to
Right.
do the final approval, right?
We're not the
We're not
bottom
the
line.
final, okay. So that last case that we denied, they can go back to the city and
They have the
we can
right,
start all over again.
they have the right to appeal to the council based
Yeah.
on the decision that we made.
Okay.
Just for funsies, what does an outright repeal look like
Section D would be crossed out,
altogether?
right?
Section D would be crossed out, and the section that followed it would be renumbered to D. There's an E that follows it.
Gotcha.
And then we wouldn't be able to,
Couldn't say no to anything.
Well,
Right, I'd rather see
It'd be
the
open.
500 and
Yeah.
300 feet limitation stay and at the discretion of the commission.
exactly.
That brings it to our attention first so we can,
Right,
Yeah.
and see if,
you know,
And this is by and large going to fall on you folks, because you guys are in charge of CUPs. Those only get up to the council if somebody appeals, which is typically when you deny one.
yes.
So this is an ordinance you guys primarily are going to be applying.
Well, and in doing our research, and I certainly encourage you folks to drive by and eyeball it if you can. Just let us know that you have made a physical inspection. But I think we need, I feel like we really need to be able to say, yes, that will work in that area, or I'm sorry, I know what you want to do, but it's just not going to be a good fit for this neighborhood or this particular portion of town. And we still need to be able to do that.
yeah.
And this is kind of just, this section D is kind of just, as I interpret it, a roadmap for us to try to make a decision that works for everyone. So, anybody got anything else they want to weigh in on? I'll entertain a motion.
Well, I'll make a motion that we amend it.
Okay, why don't you
Oh.
read that heavy print
Gotta
there?
read all that. So I'll make a motion, ordinance number, well, it's not numbered yet. An ordinance of the city,
You're adopting a resolution that recommends the amended ordinance, if that's your.
okay, of this one. It's an ordinance of the city council of the city of Selma, California, amending subdivision D of section 11.8.10, packaged alcohol beverage sales of the city of Selma Municipal Code, allowing for discretionary adjustment or elimination of density requirements for retail facilities selling packaged alcoholic beverages having less than 15,000 square feet in area where display and storage area for alcoholic beverages constitute more than 10% of the floor space of the establishment.
I have a motion. Do I have a second?
I second.
I have a motion and a second. All in favor say aye.
Aye.
Opposed? Motion passes. Now, were we short a resolution at the last meeting?
That was for,
No, a determination was made that the minutes would be acceptable.
Okay, thank you. Any questions of staff? Any street and whatever questions? How are we doing on Huntsman?
has engineering taken that to, that one's going to council. Has it gone to council?
Oh, it hasn't, they haven't broken ground on Huntsman? On the widening?
The widening was approved at the council,
Okay.
at the last council meeting.
Okay.
So
Okay.
they'll be getting some quotes and bringing that back to council for the contractor.
Are we gonna have a contest to see who gets to paint the new white line?
I'm not sure which part they're contracting out and which part will be in-house, but
Okay, thank you. Anything else you need to share with us?
I just wanted to remind the commission of a special meeting in December. Did we speak about that last time? So we were thinking because of the Christmas, well, the holidays, that the 23rd may not be convenient for everyone. So we were considering having a special meeting on the 16th. So I just wanted to remind everyone of the December 16th special meeting.
Yeah,
Will
23rd. 's
will the 16th infringe on the council?
No, it would not.
Oh, okay. Fine. With me.
Yeah, they go dark the second meeting of the
Okay.
month due to the holidays. Yes.
Well, I finished my Christmas shopping Saturday. I hope everybody likes Halloween costumes.
I got everyone candy.
I'll entertain a motion to adjourn.
Kara, was that?
I will second that.
6 o'clock.
Unless the commission would like to have it start earlier.
It's
That's fine.
16th is fine.
Move to adjourn.
Okay, I have a motion and a second. Meeting is